Today's speakers will have a lot to say about the legal and intellectual positions taken on the controversies currently surrounding mass digitization projects, of which Google is the first and prime example. It's my pleasure to introduce them, a powerhouse panel of experts on this subject. First of all, Allan Adler, Vice President for Legal and Governmental Affairs at the Association of American Publishers, Washington and D.C. office. Jonathan Band, Adjunct Professor of Law at Georgetown Law School and also legal consultant for the Association of Research Libraries. Corynne McSherry, Intellectual Property Director at the Electronic Frontier Foundation. Kevin Smith, Scholarly Communications Director at Duke University. And we warmly welcome back the moderator of the panel, Joan Chevry, Policy Specialist at EDUCAUSE's Washington office, the former chair of the Scholarly Communications Committee and former head of the library's Copyright Office. Welcome back, Joan. Welcome to all of you.
Thank you for having me. I'm going to sort of just lay the groundwork here a little bit to give some context to the issue. And so, in many ways, what we're dealing with starts back in 2004. The sort of the origin of the current dispute between the Authors Guild and HathiTrust really starts with the Google Library project, which again started back in 2004. And as you recall, Google entered into an agreement with some libraries and started digitizing their collections. And then the idea was to make to have this database which would be searchable, and then they would display just snippets, not full text. So it was sort of a scan and snippet display project. So they, again, started in 2004. Then in October 2005, two lawsuits were filed against Google, one by the Authors Guild. It was a class action on behalf of all the authors whose works were in the University of Michigan library, and the University of Michigan was sort of one of the first libraries to enter into the agreement with Google. The second lawsuit was filed by a group of publishers. And then soon after these lawsuits were filed, a cone of silence descended on the litigation, and settlement talks began, and those settlement talks continued for almost 3 years. And all the way till October 2008, when a settlement was announced. Now, the settlement was extraordinarily complicated and very controversial, and maybe some of you sat through discussions about the settlement and its merits, and we're not going to do that today. But one of the things that's important to stress is that the settlement was quite different from the initial litigation. The initial litigation, as I said, had to do with the scan and snippet display. The settlement enabled Google and a book rights registry, in essence, to provide full text access under different scenarios. One would be consumer purchase, where consumers would be able to buy access to individual books. Another option was institutional subscription. So Georgetown, for example, would be able to buy an institutional subscription and get access to this full corpus of books, which would be 25, 30 million books. Some of them would be in the public domain, maybe 20%, but a good 80% would probably be under copyright, so 20 million plus books under copyright that would be accessible in that way. Anyway, I said it was the settlement was very controversial. Ultimately, the judge presiding over the case rejected the settlement back in March. And during the Q&A we can talk about that, but at this point, all that matters is that he rejected the settlement. He indicated that perhaps a narrower settlement would be acceptable, and so the parties are in fact in the process of negotiating that narrower settlement, but any such settlement would likely go back to something along the lines of scan and snippet display and not the full text display that was allowed under the settlement. So one of the things that was going on parallel to this is when Google would scan the works for inclusion in its search database, it also would provide a copy a digital copy back to the library. And so in large measure, what we're really taught, this Hathi Trust litigation has to do with those copies, those library copies. Now, under the settlement, those copies could be covered in, if a library sort of joined the settlement, those copies that Google provided back to the libraries would be covered by the settlement. What the libraries were able to do with those copies was extremely limited. But at least they would have those copies, and certainly once they would enter into the public domain, once the copyright term expired, then the uses on those would be unrestricted. So to some extent it was like a dark archive. But one of the things that the libraries could do is they could designate two institutions which would be the hosts of a research corpus. The research corpus is sort of like the sum total of all the books. And so it was envisioned under the settlement that you would have two libraries would have sort of a copy of all the books that were in the project. They would be able to do, scholars would be able to do what was called non-consumptive research, sort of like linguistic analysis, those kinds of things, but not looking at the works for the sake of getting the information in the works, but just sort of looking at it for, again, for linguistic and other kind of research. So you would have these two host institutions that would host the research corpus. The litigation now really is dealing with those research corpuses. So what happened was the University of Michigan and Indiana University sort of went ahead and they started this process of acting in this capacity, and Hathi Trust was the name that was given for the consortium of libraries that would be working together in, for the host institutions for the research corpus. And all that, again, made sense in the context and followed from the settlement of the litigation, because that's what would have been permitted in the litigation. But as we know now, the settlement is gone, but you still have this Hathi Trust framework. You still have these sort of two copies of this huge database. Now, it doesn't have the 25 or 30 million volumes that's ultimately anticipated that Google was planning on doing, but they have on the order of 10 million volumes. Okay, so that's the amount that Google's already scanned, even more than that, but Hathi Trust has about 10 million volumes, and in addition to the volumes from Google, in addition to the Google scans, there are also, these various libraries have their own digitization projects and contributed their own works to their own copies to this database. So that's where this database came from, and that's why it has so many books already. Again, 10 million books, and a fair number of them are covered by copyright. No one knows exactly how many, but it's safe to say a good 80% are still covered by copyright. So now with the settlement gone, the collapse of the settlement, there's a question: what can Hathi Trust do with this resource, with these 10 million digitized books? And so Hathi Trust has sort of been investigating different options of what can be done. One of the things that they're looking at is providing access for the print disabled, who, of course, as you know, have a huge problem getting access to books. Also preservation. A lot of these books are older books that are not in great shape in the various libraries they come from, and so this really this project could go a long way towards accomplishing preservation of those books. And then again, the question is, what kind of access can you provide for these preservation copies? And finally, Hathi started looking into the idea of an orphan works project. Now, let me very briefly talk about what the orphan works project is. The idea was that orphan work is a work that's in copyright, but whose rights holder is hard to locate or identify. And so the idea here is that HATI members would try to identify the rights holder and locate the rights holder. If they couldn't locate the rights holder, they would put the work on a list. That list would be published. So again, the rights holder would have the opportunity to come forward and sort of claim the book. If the rights holder did not come forward within a certain period of time, then HATI would make a digital copy of that work available to the authorized users of a university library that had a copy of that book. And again, on one user at a time would be able to check out this book digitally. So in other words, if Georgetown was participating in the project and Georgetown had contributed, there was a certain book that was in the database that had come from Georgetown, or that Georgetown had, then Georgetown students and faculty would be able to sort of digitally check that book out. If there were 2 copies, then they would be able to check out 2 copies at a time. If there were 1 copy, they'd be able to check out 1 copy at a time. So that program was announced, and they started the process of looking for the rights holders, and they posted a list of about 150 works on their website so that people could come forward and claim them. The next thing that happened in September, so this is just a month and a half ago, a lawsuit that the lawsuit we'll be talking more about was filed. HATI Trust was sued by, and also the University of Michigan, University of California, University of Wisconsin, and Cornell were all sued by the Authors Guild and by 2 other associations of authors, one in Australia and one in Quebec. And they then also 8 individual authors were part of this lawsuit against HATI Trust and the universities. There was subsequently an amended complaint. We'll hear more about that. That added a few more authors associations. What's important to understand is even though in the press they talked a lot about the Orphan Works Project and how the litigation targeted the Orphan Works Project, it's important to understand that the litigation, the complaint does not address only the Orphan Works Project. It, in essence, targets the entire operation of HATI Trust. So in essence, from the moment that the libraries received the Google scans back from Google, and then they forward them to HATI, and HATI again has the 1 copy on the servers at Michigan, another at Indiana. All those internal copies, as it were, so the copy at Michigan, the copy at Indiana, all that is covered by the lawsuit as well. So just sort of the mere existence of the HATI Trust database is part of the lawsuit, as well as the Orphan Works Project. And the final point is the relief that the lawsuit seeks is that this database be impounded by the court until Congress passes Orphan Works legislation. So, until then, this database needs to remain in the dark archive. So I think that sets the context for what the rest of us will be talking about.
Okay. I think, Corynne, you were going to go next. Yeah, please.
So first, I just want to say thank you for having me. Before I was a lawyer, I was actually an academic and wrote my dissertation on academia and intellectual property. And I know there's a lot of librarians in the audience, and I just want to say you guys were my best friends when I was 22 and trying to figure out academic authorship.
And by the way, the librarians in the audience should read her published dissertation, which is still relevant, called Who Owns Academic Work? It's still relevant and excellent.
And I'm a better writer now, I swear.
We're still your friend.
So anyway, it's just always a pleasure to have a chance to talk not just to lawyers, but to come back to a university and talk about these issues. So this is a case I've been really, really interested in from the get-go for personal as well as professional reasons. My organization focuses on digital rights, and so we've been following the Google Books issue for a long time. And then when this lawsuit was filed, our sort of first reaction was, why now? And then it was, well, and why? So just to, I'll be straight about where we're coming from. But the why was also just because we saw a bunch of fundamental legal issues that the complaint raised from the get-go. And that's what I want to focus on today. Because presumably, I mean, the first instinct, if you're a lawyer, say, okay, well, the Authors Guild, we know there's settlement negotiations going on. Maybe the Authors Guild thinks that they can get some sort of additional leverage here. But when we looked at the complaint, it was hard to see where that leverage was. And the reasons for that are this. There's a series of very fundamental legal questions. Some of them just seemed to block the suit, and some just seemed really hard to resolve. So I just want to walk through what those are. So the first thing was, the initial complaint sued a whole bunch of state entities. And it turns out there's this funny thing where you can't actually sue states entities as state entities. So you can't just sue the University of California, for example, because of sovereign immunity. And this is pretty long-standing, and a lot of people don't like it, but it is what it is. As James Grumelman put it, it sort of seemed that they fumbled the very first thing you could fumble, which is who to name as the defendant. As it happens, this is something you can fix, because you can sue state officers, and that tends to have the same effect. So about a month later, they did file an amended complaint to fix that. But it was sort of like really right from the gate, you kind of wonder what the plan was there. I mean, it's not like they haven't known about this for years and had time to prepare this complaint. It wasn't, a shocker. But there was a bigger problem that's going to be much harder for them to cure, and that's the problem of what's called standing, which is sort of a basic thing. Who do you have the right to sue on behalf of? Now, the default principle in copyright is that you can only enforce the rights that you have. You can enforce your own rights. You can't enforce other people's rights. So just focusing on the Authors Guild. So they sued on their own behalf, and there's some other associations, and then there were some individual authors named as plaintiffs. Well, there's an initial question about whether the Authors Guild has the right to sue on behalf of its entire membership. But let's just say they do at least that much. They have what's called associational standing. And there's some controversy about whether that works in copyright, but we don't need to get too far into the weeds. Let's just assume that works. Okay? That's the Authors Guild. The Authors Guild is not all authors in the world, right? The Authors Guild is doubtless not all authors in this database that they're complaining about. And it's certainly not all authors in the Orphan Works project. So how does the Authors Guild have standing to sue on behalf of all of these people that are not them? And in fact, one of the issues in the Google Books settlement that Judge Chin focused on was this very issue, partly because Professor Pam Samuelson, working with other people, and we worked with her a little bit on this too, had submitted a letter in the context of the Google Books settlement saying, they don't represent me. I'm an academic author, and my interests are not aligned with those of the Authors Guild because they really represent much more commercial authors. So that was sort of an obvious problem from the beginning. And then the other thing, again, focusing back on the Orphan Works issue, is Orphan Works by definition, right, these are going to be obscure authors. They are not going to be members of the Authors Guild. And certainly the Authors Guild, it's very questionable whether they would have the right to sue on their behalf or represent them in an honest way. So this, I think, is a problem that is not going to go away. Now, one thing that was funny that happened after the lawsuit was filed is that they went and found some of the folks who were included in the Orphan Works project. And there was a lot of, oh, yay, look, see, there's an orphan, and he's not really an orphan. And so when they filed their amended complaint, they actually added one of those guys. So they managed to find one person who was willing to join their lawsuit. That's, I think it's Jose Salamanca.
Salamanca, J.R. Salamanca.
Yeah. So,
Jack, I think they call him.
Oh, Jack, that's right, they do. So Jack Salamanca, they got him. That leaves out millions of other people. And so it's not clear to me how they can possibly overcome the standing issue. So again, and this brings me back to the question of, well, does this lawsuit really bring them a lot of leverage? some big problems right from the get-go. But then those are sort of, we think of it as like procedural, a little bit issues, important procedural issues, but initial blocks. Then there's sort of the merits of the case, and sort of looking at what defenses could the libraries raise. And I will tell you, I'm not in communication with their lawyers, I'm just from the outside, what I see. There's a thing called the laches defense, and what that comes down to is, did they wait too long to sue such that the library started relying on them? That's a tough defense to make out. People have raised it, but in my practice, judges are not, a judge would have to kind of hate you to decide that that was going to work after just 5 years. It's just not, I don't think that's what it's going to be about. But then there's kind of the basic merits of the claims. Now, first of all, as I think John mentioned, a lot of these works are in the public domain, right? So for the works that are in the public domain, that's out, right? They can't sue on with regard to those works. That's not even included, so we can throw that out. Second of all, and then there's this other category of like, well, what's the Hathi Trust doing? For in-copyright works, with the exception of the Orphan Works Project, we'll get to that in a second, they're providing bibliographic information about the works in the corpus. And for people who want to do research on sort of like linguistic research, they will provide, if you do search terms, they'll tell you, or other kinds of research, if you provide search terms, they'll tell you what pages those words appear on. All of those things are facts. And so they're out of copyright too. So, okay, we can't be suing about that. The scanning issue. They could be suing about the scanning. And there we get into the fair use defense. And this is exactly the same as we're very similar to what's being raised in Google, only Hathi Trust's argument is actually better. So when you think about fair use, there's kind of 4 basic factors, which is what's the purpose and character of the use, what's the nature of the original work, how much did you take, and did you take more than was necessary for your purpose, and any mark or harm. So the purpose and character of the use, to create a database, right, a non-commercial database. That's going to weigh in favor of the libraries, because that's the kind of purpose that fair use tends to protect. The nature of the original work, kind of all over the map. Some of them are going to be factual, some of them are going to be fictional. When it's a creative work that you're starting with, that tends to weigh the other direction in favor of the plaintiffs in this case. But it's going to be all over the map. The one thing that's going to help the libraries here is that all these works are published and arguably long since published. And that tends to weigh the other way in favor of the libraries. It gets a little bit complicated, but that's fair use. How much do they take? Well, the whole thing, right? You copy the entire book. That's the point. Now, there is a popular notion that if you take an entire work, that can't possibly be okay under the fair use doctrine, but that in fact is not true. You can take an entire work if that's what you need for your purpose. And arguably that is what was needed here in order to create this database. And then finally, market harm. That gets a little bit complicated, but I think there's a strong argument to be made that there is no other real market for this database. I mean, if you had to license every single one of these works to create a database, it would be astronomical. Even Google, with all its money, I think would not be able to afford to do it. And now they have to spend a bunch of money here in DC to save themselves from bad legislation, so they don't have as much as they used to. So I think so I think scanning, you're going to have a strong, and there's some other aspects of this, but just so we don't spend the whole time, because I really want to move on to orphan works. But I do think there's a strong argument to be made for scanning, particularly when you take it in light of this sort of 5th factor, which is a combination of thinking about the public interest, the good faith of the people engaging in the activity, and the public benefit. Is it serving the purposes of copyright? And I think you can make a strong argument that creating this database, and we can get a little bit into the complexity of making it available, but creating this database and then turning it to provide information for people and making it available, there's a lot of public benefit to that. And I think a court is going to pay attention to that public interest. Again, paying attention to the public interest in incentivizing authors, right? But that gets complicated when you're talking about incentivizing people that wrote the book, 30 years ago and probably don't really have a new licensing market for it. Okay, but that's just the scanning. Here's the tricky part is the other part, the Orphan Works project. Here too, you kind of have to get into the details of it. So again, thinking about the purpose of use. Well, I think for Hathi Trust, they have a pretty good argument because of how they're limiting the availability of the works. They're supposed to be limited to students, researchers, members of the academic community, and for purposes of research and scholarship. So you say, well, that's their purpose. It seems like a pretty laudable purpose. It seems like a non-commercial purpose. So probably that's going to weigh in favor. Now, if I'm the Authors Guild, I say, well, yeah, that's really nice, but we know that students read all kinds of books, and different people read all kinds of books, and you haven't said they're just going to be research materials. Maybe it's going to be, you know, some work of popular fiction that is in copyright, and, you know, that doesn't seem fair. So it's a little wiggly there, but I think overall, because of the restrictions they've placed on who is supposed to have access to the database, or to the Orphan Works, that's probably going to weigh in favor of the libraries. Nature of the work, same analysis as with scanning. It's fiction, nonfiction. It's going to be everything. And this, by the way, though, is where you start thinking about the complexity here of trying to sue about 8 million books at once, right? It depends. It depends on the book. The amount analysis, same as for scanning. Essentially, it is you took the whole book. That's the point. And then market harm. Market harm gets a little bit more complicated here because on the one hand you have this really straightforward policy argument which says orphan works by nature are not commercially available. There is no market. That's the whole thing. They're not available. I mean, maybe in used bookstore somewhere, right? But they're not really being made available. And particularly they're not being made available online, which is sort of opens up a whole new world of accessibility. They'll be findable in a way that they aren't now. And so there's that kind of policy argument that says, how can there be market harm when we actually, the best case is we create a market that didn't exist before because someone can find your work that, like the Salamanca book hadn't been checked out in years. Checked out this book, no one knew about this book. And maybe someone would now be interested in reading it. And if a market does emerge for your book, perhaps as a result of this, your publisher, if you can find one, or maybe you self-publish, you can opt out. Right? Take your book out of the corpus and make it available. Now again, what the Authors Guild is going to say is, well, that's nice, but now it's already been made available. It's probably circulating all over the web if anyone's actually interested in it. But I have no market for it. It's been that market has disappeared. That's an argument. and because the thing about it is this is where copyright gets a little strange. Because copyright focuses a lot on whether there's a licensing market to be had. And so the argument would be, well, I know, thanks for creating a market for me, but actually it's not really being created because I can't license it because it's already made available on the web. And so really any hypothetical market you've created for me doesn't really exist because it's all about licensing. And now you've created a substitute. So why would anyone come and buy the book from me, even if I've opted out and it's been withdrawn from the corpus? The library's answer to that is that they have restricted the availability of the books. So because of those restrictions, in fact, there is still a market if you want to create one for yourself. I think this one is a little bit more of a close call. And I think then what you have to do is you have to hope, if you're the libraries, you want the judge to focus back on the public benefit, focus back on the good faith and the public policy and say, remember, we've considered these 4 factors, but then we put them all together and we think about the purposes of copyright. We think about whether we're incentivizing new creativity. We think about what's really the best way of serving the public interest. And if the judge thinks about that, and given the sympathetic status of the libraries, right, as opposed to Google, which is so commercial, and lots of people can object to Google, but the libraries, come on, everyone likes librarians. I think overall the libraries win on fair use, but it's going to get complicated. And frankly, though, I think it's never going to get there because this thing's going to founder on standing, right? Because think back again, you go to a judge and you say, how can you make a determination as to fair use? How can you even get to the merits and consider this carefully when you're talking about millions of different books, right, and that are in a whole variety of situations. So that's kind of the legal picture for us.
Thanks, Corynne. Allan, if you'd like to.
Well, I must say, I admire Corynne's confidence about the outcome of the case, because my experience has been, I would never predict what any federal judge is going to do in any instance. And just so you know that you're being addressed by a lawyer, I have to give you a kind of a customary disclaimer. I can answer questions from you about the settlement in the Google case that was rejected by Judge Chin, because the details of that are all public. Can't talk to you about the settlement talks that are ongoing now, because I'm under a non-disclosure agreement and participating in those. And as for the Authors Guild case, I can answer some questions for you about the publishers in terms of why they are not plaintiffs with the Authors Guild. But because of the rather curious love-hate relationship that exists between authors and publishers, I'm sure you can understand why, for prudential reasons, I will be somewhat discreet about commenting on their legal theories and all at this point in their case. When I was asked to do this, I was sort of intrigued by the concept of this discussion. In fact, in one of the emails, the title of this was given as a sort of a dual title. What hath Google wrought? I wasn't so keen on that, because at some point, you know, you get a little bit tired of talking about Google, and there's not really a hell of a lot more to say about them at the moment, I think. But the second title was really interesting to me: The Escalating Legal Conflicts Over Old Books. You know, as the lead lawyer for the book publishing industry on legal affairs and government affairs, I'm delighted that everybody is suddenly so focused on old books. I mean, I think that's very important, and it's sort of a signature element of the impact that the advent of the digital era has had on a lot of things, which seem to have lost their place in the world at one time, but now seem to be finding new interest, new currency, and become the focus of attention of people as they never had before. As for the escalating legal conflicts, well, you know, it's always nice that to think that the attention given to books wouldn't be one that's controversial, wouldn't be one that is adversarial, particularly when we're talking about the library and educational communities, which, after all, are two of the largest markets for the publishing industry, and we consider them ultimately partners in the larger enterprise of the dissemination of information and knowledge in society. But on the other hand, you know, when I get the courage every now and then to take a peek at the current status of my 201k, I'm very happy that these adversarial issues are in play, because it gives me something to do productively for the next, well, perhaps 10 or 15 years of my working career. So, in talking about the Authors Guild case, people seem to see a lot of comparison with the Google litigation that the publishers brought over 6 years ago, and that ultimately we tried to resolve as part of a class action with the Authors Guild. But the cases really are different, not the least of which is the fact that the publishers aren't a part of this case. And there are many reasons for that. Again, as a legal counsel, I have to be somewhat discreet about talking about the thought process involved as to why we didn't join the Authors Guild in suing half the trust and the universities. But actually, when I was advising the powers that be within my association and the members about this case, my advice was really based on something that's much more simple than the more complex legal theories and whether or not one could try to calculate the odds of success on any one of them. We sued Google because Google refused to talk to us. We had attempted back in the spring and throughout the summer and early fall of 2005 to talk to Google about the problem that its library project was causing to the members of the AAP as partners of another aspect of the Google Book Search program, and that was the Google Partners program. Many of you who are familiar with how this suit began will recall that the chronology was that Google began its book search program, and when it was trying to obtain books to scan into its database so that the contents of books could be cited as part of the results for a given subject search that anybody would make using the Google search engine, they initially turned to the publishers and in arm's length discussions and negotiations quickly developed major agreements with each of the major publishers that allowed them to scan those books and include them in their database. I don't know the details of those agreements because as a trade association official, of course, I have to walk a fairly careful line in not getting directly involved in the business of the individual members of the AAP because they're competitors with each other. And so we have to be very careful about things that involve the way they actually offer their products and services in the marketplace. But the one thing that was clear was that they thought they had a partnership with Google. And that what Google was going to be doing in the background of the deal that allowed them to scan the books of these publishers was going to be of some benefit to them. That's why they agreed to it. So they were somewhat chagrined, as you might imagine, to find out that Google then developed what it called the Google Library Project, which involved acquiring partners among the major research library university holders in this country, where the universities agreed to a basic quid pro quo, that Google would be allowed to come in, literally, I mean, you can only picture this and see how wonderful this is as an image, backing up trucks to the doors of the library and emptying their shelves and taking all of those millions of books to copying centers where Google would scan all those books into their databases. And the quid pro quo for that was the agreement, and of course we learned about this fairly early because the University of Michigan, as the first of these partners, being a public state entity, as Corynne demonstrated, their contract agreement with Google had to be a public document. So we quickly saw that the quid pro quo was that for allowing Google to come in to their libraries and scan 7 million volumes from their collection, Google agreed that in doing so, it would create a digital scan of every volume that it scanned to enter into its database and give that scan back to the university. Now, that was a very important reason why the publishers were so upset. First of all, they thought they had already had an agreement with Google about how Google would acquire the right to be able to scan works into its database. And now they were finding out that Google had a different set of partnerships through which they were claiming the right not only to scan those works that were public domain works in the library collections of its library partners, but even those works that remained in copyright. So there was this concern. We tried to talk to Google. We tried to have a dialogue with Google. Anyone who's ever tried to have a dialogue with somebody who has $30 billion in cash on hand knows that there's really not a level playing field for discussion. So in the early stages of that discussion, we tried to explain the problem that the publishers saw. And Google's response to that was basically, look, we're a technology company. We're going to have to agree that we disagree about what copyright law says about this. We think it's fair use, you don't. If you have a technology problem, let us know and we'll see if we can work that out with you. And of course, you know, the members said, no, the problem isn't about technology, it's what you're doing in the context of copyright law with your technological capabilities. And we tried to talk to them, and Google basically felt that, you know, we weren't speaking on the terms in which they wanted to have limited discussion about this issue. So the end result was a lawsuit, as frequently happens. I think most people don't realize how often the bringing of a lawsuit is simply a means of trying to get someone's attention in a serious way. And that's what it was here. So getting back to the Authors Guild's lawsuit against Hathitrust, frankly, leaving aside all the legal issues and legal theories, that was not a problem. They were perfectly willing to talk to us about the issues that publishers had, about what was being done with the Hathitrust digital collection, including those large parts of the collection that were comprised of scans the individual university partners had obtained from Google. And because we saw the beginnings of a dialogue that has continued, frankly, leaving aside all the other questions, the legal analysis and everything else, there really was no rush or immediacy to think, gee, we need to sue these guys so we could have a dialogue with them. So that's the reason why, I mean, at least in the simplest terms, we're not part of the lawsuit. Now, in talking about that lawsuit, again, we're delighted that everyone now in the digital era, despite the number of articles that you see that share the same title, some form or another, of the death of the book, the reality is books are far from dying in this age. They're simply transitioning. They're transitioning to other formats, to other means of distribution, even to other means of creation. The way in which authors decide to create their works, the way in which they decide to publish them. As you know, the advent of digital networks, the internet, has led to a new era and generation of self-publication. How successful that ultimately will be for authors is yet to be seen. For some, those who are established authors with track records, who are known to the reading public, it seems to be working fairly well. Unfortunately, not quite so well for those who are still unknown, who don't have any kind of track record, who wouldn't be recognized if their names were, skywritten to people in the reading public. No one would know who they were, and it's very difficult for them to be able to get attention, which is why you always hear about the issue of discoverability associated with books. Now, people think about that now, and they talk about discoverability because they've been hearing all of these rather exotic numbers about how many works are potentially orphan works because they're out of print books, which simply means that they're no longer being commercially exploited by the people who own the rights to them. It doesn't mean that there aren't people who hold copyright rights to those works. It just means they're not being actively commercially exploited. So while you can still pick up a copy at a used bookstore or a yard sale or someplace like that, you're not going to be able typically to find those books in a bookstore or even in an online bookseller. So the question about discoverability has become a big issue, and it is a very important issue with respect to that. But from the publishing industry's perspective, discoverability has always been a big issue. And from the author's perspective, discoverability has always been a big issue. Why? Because for the past several years, if you can imagine this, culminating in this year, there are over 300,000 new titles and editions of books published every year. And that doesn't even include, that's talking about the traditional manner of publishing books. That doesn't even include the reprints of backlist books, the things that are being done on print on demand of previously published books that are being made available through digital means of various kinds through the internet, which takes the total into the millions every year. Okay? Now, think about that. Through over 300,000 new titles and editions every year. Boy, discoverability in that kind of context, one can imagine the difficulty. Why it's hard for authors, having labored in this kind of, somewhat lonely, rather sole enterprise of creating this work and then looking how to get an audience for the work, finds it difficult to do so because just being visible in that crowd of new additions to the canon of published works is really a difficult task. So for the publishing community, they appreciate, as do the authors, the capabilities of the technologists who've brought about new means for discoverability of books. I mean, Amazon, whatever else publishers may say about them, and of course some publishers are not terribly happy with them right now over the fact that Amazon is itself becoming a publisher with no less than 6 imprints already available. Amazon does aid in discoverability, and that's a benefit both to publishers and to authors. But you still have these questions ultimately about once books are discovered, who ultimately gets to benefit from the public's awareness of them? Okay? Publishers and authors, as the people who hold intellectual property rights in those books, believe, not unreasonably, we think, that they should be able to benefit to the extent that once a book becomes known by the public and actually becomes patronized by people purchasing it and using it, that they should be able to benefit from their labors, because after all, they're the ones who made that work available to them. But that view is not necessarily shared by other communities that otherwise have a great deal of respect for books and find very important the availability of books to the public generally. And that would be the library and university communities. Generally speaking, as I said at the outset, they are very important markets for the publishing community. They also contribute, obviously, authors to the canon of works that publishers ultimately make available in the marketplace. However, they also have a different set of values with respect to what it is that they feel is necessary to do in order to make those works available to the public. They're not particularly concerned about whether anybody profits in that environment. And even though they have made, in many instances, investments in the acquisition of those materials, nevertheless, it's not an institutional characteristic of either a library or a university to worry about whether they're being somehow going to have that investment recovered by the users of their works somehow paying for the ability to use them. But that is important to the authors and the publishers who create the works. And so when we talk about the works that are at issue, both in the Google case initially primarily, and the works that are at issue in the Authors Guild case versus Catholic Trust and the universities, that's a critical element of the question of who gets to make use of out-of-print works that are not commercially available but still subject to intellectual property ownership. Now, you'll hear a great deal about two concepts in our discussion of these issues. One is fair use, and the other is orphan works. With respect to fair use, well, we could spend a day, if not a week, talking about the variations of how that concept actually works. Let me try to just mention a few salient characteristics about it. One is that fair use is, in legal parlance, an affirmative defense for someone who makes use of a copyrighted work in a manner that would ordinarily violate the exclusive rights of the copyright owner unless there is a fair use is determined to apply to that particular usage. And in trying to deal with that paradigm of how fair use applies, all I can say to you at this point, just to sort of explain part of the view of the publishers and the authors, is that both the Congress and the federal courts have repeatedly indicated that library use of a copyrighted work and educational use of a copyrighted work are not per se fair use. They may be, and it depends on the particular facts and circumstances, as Corynne outlined for you, the purpose of the use, how much of the work they're using for that purpose. All of those things go into the calculation. But that's what makes fair use so circumstantial, so situational, so specifically applicable to a particular circumstance of use of a particular work by a particular user, and not suitable to try to be the basis or foundation for the kind of edifice that either Google initially sought to use fair use for to justify what it was doing in scanning the millions of books from library collections without the permission of rights owners, or what Trust and its university partners are doing. Say whatever you want about fair use. The simple fact of the matter is, in the eyes of both Congress and the court, it's an individual user's defense. It was not meant to be the basis for a mass systematic use of diverse kinds of copyrighted works by any particular user. So that's a problem that we have. And when you talk about the issue of orphan works, which is sort of like, think about orphan works as that sector, typically, of out-of-print works that has become more difficult for users to attempt to use without the risk of running afoul of copyright law and possible infringement, precisely because the people who hold the rights to say whether that use is permitted either are unidentified now or can't be located to either give permission, deny permission, or negotiate how that use can take place. But once again, fair use cannot be the basis for deciding how orphan works in general are going to be used. It simply is not made to sustain that kind of broad systemic use of various kinds of works. So when we talk about orphan works, the problem I think that the authors and publishers community have, taking it out of the legal parlance for the moment, is simply the fact that we understand why different people, different institutions would like to make use of certain works, but have difficulty because they can't identify or can't locate the copyright owner to be able to discuss permission. The question of under what circumstances they should be permitted to nevertheless go ahead and make uses of those works that would in fact exploit the rights that ordinarily are the exclusive rights of the copyright owner is not one to be decided by fair use. And also is not one to be decided by the individual user, even if that individual user is a large university, a library, or a consortium of large universities and libraries. That, as Judge Chin told us quite clearly in his decision involving the proposed settlement in the Google case, is really a task for Congress. And the reason it's a task for Congress is that the mass digitization of books and the question of whether or not people can make so-called orphan works use of books is hardly the only question of either mass digitization or orphan works. Jonathan and I, believe it or not, spent, what would you say, about 3 years? Actually working together on the same side, trying to help Congress write and enact orphan works legislation. But our aspiration was much bolder and much more ambitious. We tried to write orphan works legislation that would provide rules for making use of works, not just books, but audiovisual works, sound recordings, all kinds of works. And not just for use by libraries or universities or other nonprofit cultural institutions, but even commercial uses. Because why not? If the point is that in today's society, with the new capabilities provided for utilizing these old works by the advent of digital technology and digital networks, we can now find new value, or even original value that was never found, unfortunately, for the creators and authors of those works. And here, I ask you to keep in mind the name Van Gogh, who never sold a single one of his paintings during his lifetime. But you can imagine the value of even the slightest of his works today. Okay? There's a possibility that with enhanced discoverability, those works that went out of print because the effort to continue investing in their marketability was not producing any returns for people, may now actually find a market, may now actually find an audience. And the authors and publishers who made the investment in time and effort to create those works, to try to offer them to the marketplace, to make the marketplace aware of them, now believe that they should be given the first shot at trying to see whether or not those works have value in the new world brought by the advent of digital technology. That's what these disputes are really all about. So keep that in mind as we discuss further.
I guess I'm last. I was a little bit afraid that I had chosen a very niche topic, but Allan just set me up beautifully. But not to disagree with him. I hasten to say there's a lot I do disagree with, but that's not what I'm going to talk about. I decided to talk to you today about, and by the way, thank you very much for the invitation, about licensing schemes to solve the so-called orphan works problem. And I want to consider what a solution to orphan works might look like. As Allan pointed out, he and John did wonderful work to create a piece of legislation that was considered by Congress in 2008 that was an attempt to solve the orphan works problem. And it would have done that by basically reducing the damages that would be assessed against a user if they had made a reasonably diligent effort to find a rights holder and had been unsuccessful. It's interesting that in the report that the Library of Congress issued last week about mass digitization, the Library of Congress said there is no reasonable way to divorce the issue of mass digitization and the smaller issue, of course, of orphan works from licensing. Which is nonsense, of course, because John and Allan had proposed a way to do that. But right now there is a heavy emphasis on licensing schemes. To be honest with you, my guess is that what is behind the Authors Guild lawsuit against the Hathi Trust is to make sure that we do not have a practical illustration of a successful way to exploit orphan works in a non-commercial way that doesn't depend on a license. I think and everybody's talking, Allan did, Judge Chin did, the Authors Guild in their complaint against Hathi Trust repeats over and over again Judge Chin's assertion that Congress has to solve the problem of orphan works. Well, what would it mean for Congress to solve the problem? Virtually every country that has attempted to solve the orphan works problem has used some kind of licensing scheme. And I think given that the alternative was never passed by Congress in 2008, and where we've come in the past 3.5 years, I think it's very likely that any legislative solution, and you all laughed at the idea of a legislative solution, but if we're talking about a license that could actually make money for some groups that have powerful lobbies, I'm not so sure you should discount the possibility that Congress would adopt a licensing scheme.
Unless you
for orphan
characterize
works.
it as a tax.
Unless you characterize it as a tax, which of course, if it was onerous enough, would be the thing I would do immediately, as I'm sure you know. So I think it is worth thinking about what these licensing schemes would look like. And as I said, the Library of Congress in their report on mass digitization talked almost exclusively about licensing solutions. Now, orphan works is a narrower subsection of the mass digitization issue, but still I think that that's important. When we talk about licensing schemes, I think it's really important to keep in mind the issue that Corynne mentioned when talking about the Hathi Trust lawsuit, about who represents the orphan work authors. Because we're talking about orphan works. We're talking about works where we cannot locate a rights holder. That means the rights holder is not Macmillan, it's not Duke University Press, it's not a publisher we can get in touch with, it's not a living author we can identify. Jack Salamanca was a bad mistake. So the question is, who represents orphan works authors, and who should be allowed to sell rights in their works? A licensing scheme is inevitably going to give someone who is not the rights holder the right to sell a license. I want to describe to you for a minute the experience in Canada. Canada has had for quite a while, I believe since 1990, a licensing scheme for the use of orphan works. It's described very nicely if you're interested in an article by Jeremy De Beer and Mario Bouchard in the Oxford University Commonwealth Law Journal. Don't let that frighten you. It's not that hard an article to read. I got through it. So, in Canada, an administrative board that's established by the government, the Copyright Board of Canada, is authorized to grant licenses to users for certain uses of orphan works. It applies only to published works. The applicant has the onus of convincing the board that they have done a reasonably diligent search, that was the language in the United States, but have made reasonable efforts to locate a copyright holder. The board does not have formal standards for what a reasonably diligent search is. The legislation that Allan was talking about did have much more detailed standards than Canada uses. Their informal practice is really interesting because the things that the board in Canada identifies that it looks at are things like, what type of work is it? What kind of use is proposed? In fact, they look like the fair use factors. So it's very interesting to see that what the board uses to assess the necessary search look a lot like our fair use factors. One factor about the Canadian licensing scheme is that licenses always require payment. The board does not authorize unpaid licenses for the use of orphan works. Often, those licensing fees are collected by one of the collective rights organizations in Canada. So if you want to use books, the fees that are assessed by the Copyright Board will be paid in all likelihood to a collective rights organization for books. Also, those collective rights organizations help the Copyright Board in setting the fees. Usually, in most of the orders that the Canadian Board has issued, they say that the collective rights organization is to hold the money for 5 years in anticipation that a rights holder might come forward and then be entitled to the payment. After 5 years, that money simply reverts into the general funds of the collective rights organization. There have been 441 applications to the Canadian Board since 1990, between 1990 and 2008. 230 of them have been granted. Most of the applicants were seeking to use a single work, about 60% of them, but a handful of licenses were granted for large-scale uses of orphan works. Now, this is what the Library of Congress report calls an extended collective licensing scheme. That's a situation where the government mandates the license, but doesn't set the terms. Individuals can negotiate the terms, and in the case where the rights holder is known, they can opt out. Of course, in an orphan works scheme, there isn't a rights holder to opt out, and if a rights holder comes forward, it's no longer the work is no longer governed by the orphan works license. There are some advantages to extended collective licensing. It reduces transaction costs. You know, where we have a relatively convenient licensing scheme, it always reduces the transaction costs. They're much lower than they would be if voluntary licensing was the order of the day, because voluntary licensing requires you to negotiate with each rights holder. And, of course, with orphan works, there isn't anybody to negotiate with, so voluntary licensing doesn't work anyway. Arguably, a licensing scheme like the one established in Canada applies consistent standards. Now, I said there aren't actually formal standards that the Canadian Copyright Board has identified, but there's a pretty good working knowledge of what the standards and regulations are going to be. And of course, the other advantage is that if you get this license, which is mandated by the government, if you get this license, you have certainty, you have protection. You know, Allan referred to fair use as an affirmative defense, and I would point out that the law never actually says that. Congress never calls it an affirmative defense. Congress calls fair use a right in Section 108 of the Copyright Act. But that's a terminological debate we could have. As a practical matter, fair use is never certain until a judge tells you it was fair use.
That's an ecclesiastical discussion.
Well, you know,
I have a case where we're fighting that very.
my background is my graduate work was originally in theology.
Well, then
and
you
so
have an advantage.
I've always appreciated Judge Story's remark that copyright was the closest thing to the metaphysics of our law, because I was well equipped to deal with the metaphysics. Boy, now that's put me off my stride. Okay, I had finished talking about the advantages of a collective licensing scheme. What are some of the disadvantages? One of the obvious ones is that no matter how low the cost is set, it is inevitably going to discourage some uses that could potentially be beneficial. Since we are often talking about very, very obscure works, like Jack Salamanca's The Lost Country, but never mind. We're often talking about works that, as research librarians, we know are exactly the works that somebody needs, but not everybody. In fact, maybe only one or two people. So the marginal cost of getting that license, even if it's very low, will certainly discourage some potentially beneficial uses. One question, whether it's a disadvantage or not, is who should administer this license? Canada uses a government board, an administrative board that's set up by the government. I think that's a very unlikely solution in the United States. And even in Canada, the board defers to the collective rights organizations. So the question is, could a collective rights organization, and this is a loaded question in a room full of librarians, could a collective rights organization like the Copyright Clearance Center serve as the honest broker for licensing of orphan works? I knew I'd get that reaction. I couldn't resist it. A big question is how a licensing scheme for orphan works would relate to other user rights. And this is a question they have in Canada. It's an ongoing debate in Canada, but it's made far worse in the United States, where we have this open-ended user right or affirmative defense called fair use. Would the board make a fair use determination before determining whether or not a license was appropriate? In individual circumstances, Allan wants fair use to be applied in individual circumstances. We're talking about specific applications. Would the board make a fair use determination before assessing a licensing fee? If they did, would that fair use determination have some weight in court? How would a licensing scheme relate to fair use, as well as the other exceptions in the copyright law? And by the way, one of the issues when we talk about how fair use would relate to a licensing scheme is to remember the fourth fair use factor is impact on the market. A licensing scheme itself creates a new market. So you have a kind of circularity problem. Last thing I'd note is that, and I was surprised by this, the Library of Congress report on mass digitization dismisses fair use as a potential solution to that issue as a whole, for many of the reasons that Allan outlined. But it does not address fair use specifically in the context of orphan works as a distinct category. I would suggest that any solution to the orphan works problem in the United States must look at fair use, and here I realize I'm disagreeing directly with Allan, and determine its applicability as a baseline from which a more complex solution like a licensing scheme can be built. And that's what I have.
Can I just make one comment on your last?
Of course.
I don't think we're really in disagreement on the applicability of fair use in the orphan works context, Kevin, because what I was saying was I don't believe that fair use can serve as the legal justification for an entire system or process or set of procedures for determining what works are orphan works, may be considered as such, and making the judgment about whether or not one can go ahead, and then what would the consequences, if any, be should a copyright owner subsequently emerge. When we were working on that legislation, we acknowledged that in an individual case, of course, fair use would still be a valid defense for an individual to offer if, in fact, subsequent to their use of a work as an orphan work, a copyright owner emerged and said, hey, you don't have the right to use my work, or if you're going to use it, I want compensation. Okay? They could still make the fair use argument. My argument was that what the University of Michigan seems to be doing, at least if you assess the statements by people like Paul Corynne and others who have explained the basis for what they're doing, they're saying that the entire orphan works project is fair use based. And that, I think, stretches it too far. That was what my point.
And the only qualification I'd make to that is you said what Michigan is doing, and I would point out that Michigan has not made one single orphan work available to one single student on any single campus. They have not done that. The lawsuit was filed based on a list, not on actual availability.
Right,
so
but
we should put that in the future tense.
Sure, because the thing that's in the middle is we do know what their intent was. That when they tentatively designated a work as an orphan work,
right,
based upon whatever search they did, their position was that if they posted that fact online for 90 days and a copyright owner did not emerge to claim that work, that was sufficient for them now to go ahead and authorize use of the work. Now, Corynne makes the argument that, well, they proposed a very narrow and limited use of the work, and therefore that was part of the basis of justifying it as fair use. That's true. I think it's wildly insufficient because, and this is why I said our legislative aspiration was much bolder and more ambitious. We were trying to say, look, it's not just limited. If it is in fact an orphan work, you're not just limited to making it accessible for students or faculty for research. You can commercially exploit it. You can do all the things that you can do with copyrighted works if, in fact, you had a scheme in place that was uniformly applied as law so that people were operating under the same procedural requirements and with the same consequences.
But in the absence of such a scheme, we're looking at a much more limited application that we think could fit under fair use, and
that's where we disagree.
That's where we
Let's
disagree.
let Jonathan speak a minute, Corynne, please.
Sorry.
No, I knew I was going to
I
bring
just
it
wanted
up.
to jump in and say, have 2 points here. First of all, in response to Allan's point about that you can't use fair use for sort of a systemic as a systemic solution to a problem, I think that that's just flat out wrong. Courts have, in numerous cases, applied fair use to basically a business model that applied to many works at the same time. Let me just give you a couple of examples. First of all, 2 courts have found that the operation of search engines, where they sort of scan huge amounts of works and store them in their databases, and then display, whether it's a thumbnail or whatever, that is, even though there's a huge amount of copying, that's basically a fair use. Now, to be sure, it could be that in any one specific case that a court might say, no, well, in this specific case, it's not a fair use. But there you do have business models, businesses that are based on fair use. And so you have, sort of all of Google's market cap is based on fair use, because that's how search engines run. They copy the entire World Wide Web repeatedly, and they're operating under a fair use theory. There's also, but even if it's not just search engines, there was a case right here in the Fourth Circuit, the iParadigm case, which involved a plagiary detection software system where iParadigm is copying, hundreds of thousands of student papers on an ongoing basis, and then a student uploads additional papers to compare. If it's certain papers, he uploads it, and those are compared to the iParadigm's database. Now, iParadigm was copying all these works without the authorization of the students, and so the whole business model based on copying large amounts of material without authorization of many different authors, and at least with respect to the specific students who sued, the court said this is a fair use. But again, the basic premise of the business model was fair use. And the final example of that I want to bring is, just so we're saying, it's not just these crazy courts of appeal on the East Coast and on the West Coast. The Supreme Court in the Sony Betamax case, that case is also based on fair use. That had to do with the permissibility of the VCR, or actually the Betamax the Betamax machine, which was a form of a video cassette recorder, and the premise of that they were selling a device, but the argument was, well, this device is enabling copying. But the court said, yes, but that copying, a lot of that copying is non-infringing, and talked about all the time shifting that users do when they program their VCR, now their DVR, to record Survivor, when it's on at 9 o'clock on Wednesday night, so that you can see it the next night if you happen to be out. The court said so again, this is a systemic thing, and this is, again, the basis, really, when you think about it, this is the basis of all VCRs, all DVRs, frankly, all computers. I mean, all of these devices enable copying for later use, and they're all premised on a fair use argument. So the notion that you can't have a business model that is sort of premised on systemic fair use analysis is just flat out wrong. If it were, we would be back in a world with no digital devices at all. Still, you can be found liable in a particular case, because a court in a particular case can decide that you've copied too much. But still, the notion that you can't have a business model based on fair use is just completely wrong.
Well, it shouldn't surprise you that I disagree with Jonathan about the cases he cited. I don't want to get too deep into the legalistic woods here, but on the question of the search engine, the cases he talked about, they never should have reached the fair use issue, because in both cases they acknowledge that really what search engines do is act on the implied consent of the websites whose works they index. And the reason that they said that is quite obvious. Every search engine, including Google, acknowledges that if a website owner uses technology to send a signal to the web crawler that says you do not have permission to collect and index the content on my website. The search engines honor that. Now, the whole point of the fair use doctrine is to allow a user of a copyrighted work to be able to use it despite the explicit objection of the copyright owner.
Which was the case in Sony.
Which was, okay, and Sony, I mean, citing a case, first of all, citing a case that preceded the digital era, I think even the Supreme Court today is having some troubles about what to do exactly with the Sony decision and trying to apply it to digital technology because it's so different. Plus the fact that that was a highly divided 5-4 decision in which the court couldn't decide whether or not the TV broadcast industry and the movie industry really cared about whether or not people were copying their content simply to be able to view it at another time. Not to be able to distribute it, not to be able to create libraries from it. So that's another lecture.
Yeah, thank you. Corynne, now that you take a drink of water, let me give you a chance to respond. And then I want to say, because we all agreed ahead of time that we wanted to turn it over
Sure.
to let people ask the questions as well. So take your time, but
So I want to just make a couple comments about what strikes me as the at least two elephants in the room. One of which is the copyright term, and the other of which is statutory damages, because it's, that matters for the rest. So what happened is Congress created this problem in 1976, and then it made it worse a couple of decades later, right? We had it used to be that if you wanted to assert rights, you had to register, you had to put yourself out there, you had to make claims. And now we don't have that principle anymore. Okay, we're stuck with that. That's old news. But then we have this copyright term that gets extended and extended and extended, and every time it's extended, effectively it creates more orphan work. So you guys know this, but it just strikes me that we can't have the whole conversation without acknowledging that Congress has done more to create this problem than it's ever done to solve it. And which is what makes me a little cynical. I know I'm here, and we should all be happy in DC, and I know good things happen here, but in San Francisco, it's not looking too great. And then the other thing is the statutory damages, because that's the thing, and I think particularly when you're talking about conservative institutions, not Google, but universities and libraries that are going to think about, and whose counsel is going to tell them to think about the max, not the minimum. When we think about what the risks are, it's really going to scare people to take that chance to even assert the fair use defense for in a lot of situations. So again, I just feel like that we have to acknowledge that in the context of this discussion if we can understand what the actual legal risks are. But I want to get back to this notion of, okay, but if there was a constructive solution, what might it be? What could it look like? And my recollection, and these guys over here were much more involved in the details of this, is the reason that orphan works legislation foundered last time, which my organization totally supported. I thought it was a great proposal, because I agree that it should be all kinds of uses, not just educational uses and research uses. It should be all uses. It foundered on the visual artists, who felt that they were in a different category. That, because if you do a painting and it's made available online, someone could just take your whole work, and didn't want to sort of go through the effort of there was a sort of a scheme for due diligence and registering potentially, and it was a little bit complicated. But it seemed to me that that's really where it foundered. It didn't founder so much on if you think of the word people. It foundered on the visual artists, and they mobilized and they did a really good job of stopping a really great piece of legislation. So I wonder if, getting back to your solution, or getting back to how we might think about it constructively, is, much as a global approach might be appealing, maybe one thing to do is start out with a narrower set of works and see if we can get Congress to agree to that and get on board with that, and then start building on, once we show that a licensing scheme of some kind works, other people might want to join in on and get in on the action. Right now we have collective licensing for music. We don't have collective licensing for everything. We have it for music because that makes sense in a lot of ways. And a lot of people have problems with BMI and ASCAP, and we don't have to get into that. But the point is that for a lot of people, it basically kind of works. And so maybe if we're going to start thinking about practical solutions, we should start thinking about not trying to get every different kind of work lumped in at once, but start a little bit smaller, and then when people realize that people are making money, they want to join in the group. Now, the one other thing I would say, my cynical self thinks that one of the reasons that the Authors Guild filed this lawsuit is maybe they're looking ahead to some kind of collective rights organization, and they want to make sure that maybe they're administering that pot of money. So when that 5 years expires, I don't know where that's going to go to, but some of it will go to them. But that's really cynical, and I'm sure.
I think I started on that premise, so I'm as cynical as you are.
So first I want to thank all of these people. They're articulate and passionate.
I don't know many academics who are millionaires based on what, even books that they publish, but my question about this is the potential market. It seems to me that authors are very concerned, particularly commercial authors, are very concerned about the potential for the market of their, and the value of their works. Is it possible that with this licensing scheme that you referred to, Kevin, that there is a tipping point or a threshold of downloads or hits or whatever on a particular work that would then trigger, you know, some sort of paid scheme, rather than going through this, you know, worrying about something that doesn't even exist? It just doesn't make sense to me. We're trying to predict the future, and I understand that from the person who has put, you know, all of the effort, all of the work, the years of research, whatever it may have taken to create that work. But it's out of print. It hasn't had a, you know, it hasn't been used. Even if it's discoverable now because of the web, what does that really mean in terms of the royalty or the payments that that individual would receive?
I think you could develop an
really
interesting.
benefit.
I think you could develop an interesting scheme based on what you've just said, where, for example, a licensing board could say this use, because it's beneficial for all kinds of reasons, because it's very marginal in terms of the popularity of the work, this use will be uncompensated for some period of time. In other words, we'll grant you a license for 3 years without asking you to pay anything. And then we'll revisit it and consider whether, because of the amount of, I mean, you could craft things like that. You could craft things where there was, in fact, a fair use determination prior to a licensing scheme. You could do that. That's where I think we start to get into some real unlikely negotiations, but you could do that.
But in the orphan works discussions, one of the ideas that I think I suggested, no one else agreed with it, but precisely because of that, you know, and again, the whole orphan works legislative idea was to sort of reduce or damages if you did the reasonably diligent search. But there was, you know, sort of floating in the background was this concern about, well, what happens if somehow, you know, the orphan is discovered and then the user somehow makes a ton of money, and that wouldn't be fair. And so I think the idea was, well, maybe, you know, that what I was suggesting is that maybe we should come up with like windfall profit language, that if somehow the benefit was sort of beyond all expectation, then there would be a way to give added compensation to the rights holder beyond, you know, what you otherwise would have compensated, which could be very, very little. I mean, you know, if the idea is, okay, you would have just been paying a license fee. If whatever the market value of the license would have been if you had found him, but for a lot of works, the license value would be zero or a very, very few dollars. But again, somehow it hits the work hits the jackpot. You know, and I think there could be in either a licensing system or a legislative system, there could be ways to adjust for that. But rather than sort of be so afraid of the possibility, you know, let's design a system that, you know, keeps costs down up front, and then in the event of something that seems unfair, find a way to compensate the person in that situation. And even within the hockey trust framework, I mean, to some extent you prevent that problem, because if you're only making it available to the users of the community, you don't have that problem of the work sort of getting out and harming some other market that might emerge. You could also say, well, look, if you know, you were talking about the Salamanca book that had not been checked out in 10 years or more, you could say, well, if a book, it turns out that somehow all of a sudden there's this big demand, that even though the book had not been checked out, the hard copy hadn't checked out, it was now, it's discoverable, it's discovered, and now people within the academy are checking it out much more, then you could maybe decide to treat that differently and really find a way to find the authors. So there are ways of dealing with that problem, but the point is, it is so unlikely, or it is like that problem is going to emerge very rarely. So to prevent uses, or to say we're going to design the system to upfront to prevent that situation, rather than figuring out an after-the-fact way to compensate the rare situations in which they arise, I think is kind of putting
Yes,
it back.
to use the popular language, is it going to be for the 99%?
But you know, you raise a very interesting point, and this is an argument that I lost with the Copyright Office very early in the game, which is that I think orphan works is a misnomer, and it creates a great deal of understanding. What we're really talking about are orphan uses, because the one thing that is clear is that no one believes it is appropriate to designate a work as an orphan necessarily for all uses. Part of the reason for that is the simple reality that under copyright law, the way in which copyright owners' exclusive rights are exploited is that they inevitably get divided. So that the exclusive right for reproduction may go one way, the exclusive right for distribution or translation or adaptation may belong to somebody else. So what we're really talking about is the fact that a particular use that does not fall within an exemption, probably is believed not to be protected by fair use, if a particular use wants to be made, that's orphaned because you can't find the person who can give the permission for that use to take place. I think that's another part of the problem that people have to deal with here, because unfortunately the phrase orphan works tends to make people think that if a work has been viewed as not having a findable copyright owner to give permission for one purpose, that applies for any purpose with respect to that work. That has also led people to unfortunately wrongly conclude that works that are out of print should be treated as orphan works, even though it's clear that they're still subject to copyright ownership.
Karen.
I just wanted to call Team Authors Guild here because I didn't hear. I'm actually a member of the Authors Guild. I have the privilege of knowing Jane Constantine, the General Counsel, and Paul Aiken. And it's funny because a lot of the conversation about why did they bring this lawsuit, and I certainly am not going to speak to why they brought this lawsuit. You know, I think that those reasons are many, complex, and beyond my ken. But I did feel that they spoke for me, and I cheered very loudly when the lawsuits were brought, because my sense was, big picture, what the Authors Guild has accomplished. And in the words of Roy Blunt Jr., when he was talking, he was the president of the Authors Guild the year that, I think he was the president the year they sued Google.
Mm-hmm.
He said, the statement was, you just got to go ahead and trust us that we're going to be good guys on this. We're going to take your works and we're just going to treat you fairly. And he says, the hell you say. And what the Authors Guild has accomplished to me in the big picture is they have said, if one of these things goes forward by benevolent people, by non-benevolent people, commercial, non-commercial, I don't care, you know, who you kind of say you are, in their opinion, it seems to me they're saying, and you're going to have us at the table. And we will, as authors, participate. I see it as a union, really, basically. We as authors will participate in a discussion about how these things are structured. Now, you could very sensibly argue, yeah, but I don't think the Authors Guild speaks for all authors. You said that. It doesn't speak for all authors, but what it's had a fabulous effect of doing is saying, if one of these things goes forward and we're not in that conversation, we're going to do, and I mean, I was very interested also when you said that there were certain steps that they took in filing a lawsuit that were problematic. I'd love to look at that more closely. But they said a lawsuit's coming. We're going to have the conversation. Did they do it right? I don't know. You know, I'm not a lawyer. I don't know. But as an author, I got really, really excited because I said somebody powerful with a loud voice and the ability to grab headlines is forcing me to the table, even though I have not the money, the resources, or the time to advocate for myself. And so that's why I keep giving my $90 a year. Your dues structure is based on how much you earn in royalties. And my 2 books with FSG, very proud of my publisher, but they're out of print, so I give them $90 a year, which is the bottom dues structure. But that's why. Do I always agree with everything they do? No. Sometimes, in fact, I think that I would probably take academic issue with it, but I'm thrilled that they're doing it. So I just kind of wanted to call team here. And I'm thrilled that you guys are pushing back I mean, it's very smart what you're saying. I love the conversation, but I also love that they're in it.
Well, I mean, just again, just one of the factual problems is that the authors and the publishers were invited to the table to discuss it.
Yeah.
The authors, the publishers took up Hati's offer to have that conversation, and the Authors Guild sued rather than have the
And that's the part that's why I said I'm
right,
very, very interested in what you perceive as their missteps, because I would be very comfortable not just acknowledging, but raising an eyebrow if I thought some of these missteps were legitimate. But I'm just, maybe I also, part of me loves a good scrap. I probably should have gone to law school.
Jen?
I'm looking to the future, of this question. Chin wanted, thinking that Congress would solve it, the orphan works legislation fell through. Who's going to put an answer to this? Is it going to be another lawsuit? Is it that, everybody just wants an answer? Just give us an answer. Or is it, Congress is stuck. It's not going to do anything. That's why everybody laughed. Because we knew nothing's going to go for the next 2 years. Where is can the executive branch do something? Is there any other place that we can find an answer?
I think you have to recognize that an answer, a comprehensive solution, is a long way off and maybe a fantasy. What is going to happen is what has happened for many years. We're going to chip away. There are going to be decisions that libraries are unhappy with. There are going to be decisions that publishers are unhappy with, and we're going to continue to negotiate the boundaries. I think that's, maybe you have some other wisdom.
No,
but that's what I think is going to happen.
I would say to it that, part of the reason we did not join that suit is that, again, it's based on, when one engages in litigation, among the things that are experiences of life that you should learn lessons from, damn, if you don't learn anything from engaging in 6 years of litigation without resolution, you're not paying attention, So I'm very hopeful that in this area, it's quite possible that, private-public partnerships might emerge where there are seen to be benefits to each community or the multiple communities that come together in that kind of an arrangement. And maybe, just maybe, we can do this without having to get either Congress or the courts ultimately to make the decisions. Now, that's not an easy road to walk either, but in many ways it does have a lot of preferences to pursuing the others.
The orphan works are still out of any of those agreements then?
Well,
Because they're not at the table,
Right.
and they can't be.
Yeah.
That's a problem.
That's a problem.
Everyone knows
to
it.
some extent, and to some
Everyone knows.
extent, I think that's what Hati is trying to do. You have, this database gets collected, that gets created in the context of Google, and then the settlement, the proposed settlement. That's how you end up with this big database. Settlement collapses. You say, okay, what do we do now? You do have fair use. You try to come up with creative solutions to a problem because exactly, Congress is not going to solve the problem. There is no one to reach an agreement with, or the cost of trying to reach an agreement with every potential rights holder is enormous. So you try to come up with a responsible, limited solution. And again, with Hati, not only with the orphan works, not only were they. I did at first say, to put the list up and to give people the opportunity to say, don't do it. Here I am, I don't want you to do it. But certainly the understanding is that certainly after the fact, if at any point the rights holder steps forward, they would stop the use. And also, again, the use is very, very limited. It's not making it available to the world, as would have been the case in the orphan works legislation. Or the orphan works legislation, Georgetown would have been able to, once it did its reasonable diligence search, it would have been able to make it available to the entire world until if the rights holder emerged and then Georgetown discontinued the use, at that point it would not have to pay any kind of fee at all, no compensation at all. So what Hati is doing is trying to deal with the reality of no congressional action likely. All these other solutions aren't feasible. You do have a database. How do you go forward?
John?
The one thing that I thought that Google potential settlement did is it sort of revived the idea of an abandonment of rights,
Right.
that you don't positively affirm them, and therefore, you know, you can be alive, you can know it and still abandon your right and make it an orphan work and available out there. Is that concept completely dead in the solutions that are being kicked around?
Well,
One thing that
Go ahead.
One thing that I know is being kicked around internationally is trying to, and it's going to be very complicated to see what this means as a practical matter, but trying to create some sort of international registry, trying to basically reverse many decades of copyright policy, which has said, no, you don't need to register, you don't need to identify yourself, you create, this is all copyrighted right here on the page. And so at least trying to create some international registry so people could step forward, they could claim their rights and begin to build that. And I know that a lot of different people from a lot of different sides are trying to think about whether that's a good solution. And from EFS perspective, I'm not sure where we fall down at the end of the day, but it is, I think, internationally people are recognizing that how are we going to fix this when there's, maybe we need some sort of positive database where people say, I do care about my work. I care, I want to be contacted, I want to be reached out to, I want to step up.
Which was the system the U.S. had until
Yeah,
1976,
right.
1978.
Yeah, but there's a reason why the U.S. changed that system. I mean, they didn't just abandon registration out of a sense of irresponsibility. They did it in order to join the Berne Convention, in order to participate in an international regime of copyright protection, which they foresaw correctly, because we are the largest exporter of cultural product, was going to be very beneficial to U.S. creators and the U.S. economy. And they did that because under the Berne Convention, there was a prohibition against national laws of Berne members imposing what they called formal requirements. Because the feeling was that other countries, which would be entitled to equal protection, their creators would be put at a disadvantage if they didn't register their works with the U.S. Copyright Office, for example. So there was a rational policy behind it. Now, Corynne is correct. Notwithstanding the rational policy behind it, one of the consequences unanticipated was the idea that we unmoored all of those works from any notion of who actually created them and who therefore is entitled to assert and exercise property rights.
Or even rights holders, there's people
Right.
just any.
But the problem with the concept of
cares?
abandonment of rights in this area is that you have to be really careful of how that would work, how that would operate, and what the triggers for abandonment would be. In today's marketplace, and especially given the ability to bring your works to the marketplace through digital networks and various digital formats, there are now different ways of doing it that might appear to some people as if you have somehow abandoned your rights, but you haven't. I mean, the most popular example that everyone is aware of is Disney has developed this marvelous policy with respect to its feature animated cartoons, that they announced publicly that this is going to be the last time for the next 15 years that you can buy a copy of the movie Snow White and the Seven Dwarfs, right? Why do they do that? Because they know that if they let this thing stay off the market for a generation, another whole generation of parents and grandparents are going to be out there buying this as if it's a brand new movie. Okay? But that doesn't mean that during the 15 years in which this movie is not only technically, but legally not commercially available, that it is in any way to be considered abandoned. So you have to deal with those kinds of issues, and it complicates the question.
And it gets us back to the complexity that now copyright covers so many different kinds of things,
Yeah.
the vast majority of which have zero value.
Right.
But we're applying a law for Disney, for Macmillan, for the people who are legitimately trying to make money and successfully trying to make money from works. We're applying it to all kinds of things, including academic works, for which it doesn't fit.
Right.
I hate to be the bell ringer, but we're at the end of the time, and I was told that this room is going to be used after this, so I don't think that I can let it go on. Please join me again in thanking all of you.